Good morning, sir. Sir, Dixit sir is joined, sir.
Thank you. इसमें भी श्री जेटली जी ने 20 मई 2014 को मैं गाड़ी पे चला रहा था, गाड़ी का एक फोन आया 4 बजे से शाम में कि तुम कहाँ हो? मैंने कहा मैं अब घर जा रहा हूँ काम कर। तो बोले कि गुजरात में आ सकते हैं आप। मैंने कहा "आ जाओ।" तो ये तो मुझे समझ में आ गया कि गुजरात में उनका क्यों बुलाया जा रहा है, जाहिर है मिलना होगा। खैर मैं पहुंचा 20 को, सीधा साक्षात्कार हुआ। मैंने
Very good morning to all. As per our Saturday's series, today we are going to discuss again on the Legal Metrology Act and the Packaged Commodities Rule. Very good morning, sir. Sir, today we are planning to have again a presentation on the legal methodology, because again we have seen that the new GST reforms have come into force. So accordingly, the legal methodology has also allowed to revise the MRPs wherever required for next 6 months, as we were doing earlier in 2017, 19, 18, etc. So first of all, sir, I would like to request you to kindly speak 2 words. Please, over to you, sir.
Okay. So, Dr. Ashutosh Agrawal, Director Legal Metrology, Government of India. So, I think the Government of India has done the great job to reduce the GST and its implications is lying on various departments. One of the department is Department of Consumer Affairs, that is the Legal Metrology Department. So legal metrology, the director is responsible for all these very issues. So I have seen that you have issued the representation direction to the all the controllers legal metrology. But in the fields that I had seen in Uttar Pradesh, the uh, chief minister itself is going on in various markets to see that whether the GST has been reduced or not. The things are very common there in TV. It has been shown that many this owner of the market means the shop owners. They are telling that we have got on the higher rate how to reduce the GST. So that issue is the great issue. Even I think that at the ground level, the manufacturer might have reduced the GST, but the main issue is that the whether it is reduced from the wholesale stockist to uh, retailers levels. That is the very important thing. On that very issue, you have to do the always discussion with the controller legal methodology, as well as the you have to issue the guidelines, and whenever you are getting a complaint that you should not issue that very complaint to that controller, but the copy to the all the controllers, so that everybody should feel that there is a problem from the shopkeepers levels, and that has to be removed. So this is the only problem. Otherwise, you have taken the very good step from your side, and the manufacturer and importer, they had decided to reduce the GST from their own levels. I think that it will take one time to reach at the retailer shop owners, and then when they will sell their new stock, then the consumers will be benefited. Till that very time, we have to continue the discussion with the controller legal methodology and all that very things. I hope that you are doing every week some conversation with the industry people and the controller legal methodology, and there this issue might have been raised time to time. So that is a very good step from the Department of Consumer Affairs, that the department is taking initiative for the good cause of the people. I hope that the your step will be very successful, and it will be beneficial to the all consumers. Thank you, Astoji. Thank you for this very program, when you had considered that there should be discussion on the GST level. Thank you all. Wish for the success of the program.
Thank you, sir. Thank you very much for your kind and motivating words. Thank you, sir. So actually, the plan is to discuss again this Legal Metrology Act, as you are very well aware of it, and being having the understand and basically made this complete act and rules. You are aware of all. Sir, I would like to start with your kind permission. The provisions of the Legal Metrology Act and the packaged commodities rules and the other rules made under the Act. Legal metrology is nothing. It is the application of legal requirements to measurements and measuring instruments. Basically, all type of weighing and measuring instruments and the measurements or the weighing which are taking place are covered under the legal metrology if we are putting them under the legal requirements. The purpose of the Act is to establish and enforce standards of weights and measures. We are all aware the country, all the countries have made their own standards of weights and measures, but they are all internationally traceable. So to enforce and establish the standards of weights and measures is the responsibility under the Legal Metrology Act of the Legal Metrology Departments to ensure correct quantity in transition and accurate measurements or measuring instruments for transaction or protection, regulate trade and commerce in weights, measures and other goods which are sold in weight, measure or number, regulate sale of prepackaged commodities. This is the basic requirement of the Legal Metrology Act and the rules. As we are all aware, this legal metrology is not a new subject. It has come from the constitutional provisions, entry 50 union list, establishment of standards of weights and measures, and concurrent list, list 3 of entry 33A, weights and measures, except establishment of standards of weights and measures. So the standards of weights and measures establishment is the responsibility of the union government, and apart from establishment of standards of weights and measures, the responsibility is the joint responsibility of the states and the central government. I have a small video. I will again run this video.
In Bharat, several ancient scriptures of Vedic period.
Video is visible to all.
Mention weights and measures.
Atulji, can you please see whether the video is okay? No, thank you, thank you. I will share it. Okay, thank you very much. Thank you. Video is not visible. I am just sharing you again. Just a moment.
Bharat. In Bharat, several ancient scriptures of Vedic period mention weights and measures. We have recorded history of measurement system in Indus Valley civilization with surviving samples. Uniform units of length were used in the planning of several ancient sites. Later, metrology flourished during Maurya and Mughal empires with the development of standard units for length, weight and volume. Metrology took a definite shape during colonial period, but independent Bharat adopted the international metric system in 1956. Legal metrology is contributing significantly in promotion of trade and exports by quality and quantity assurance in global markets. By adopting international standards, legal metrology is promoting trade and export of weighing and measuring instruments worldwide. A robust legal metrology framework ensures public guarantee of precision, security and accuracy in various types of weighments and measurements. Mandatory declarations on packaged commodities have ensured safety of general consumers. A network of state-of-art regional reference standard laboratories provide technical support to legal metrology by verification, testing and calibration of weighing and measuring instruments. The Indian Institute of Legal Metrology at Ranchi imparts professional training to national and international participants from neighboring and developing countries in legal metrology. Much to our pride, Bharat is now issuing authority to the International Organization of Legal Metrology Certification System, in which measuring instruments are assessed and verified in an authorized laboratory. Recognition by OIML is a milestone global achievement testifying technical prowess of Bharat. Legal metrology has become one of the torchbearers in New Bharat, paving way to make it a $5 trillion economy by 2030.
Thank you. So, as we are all aware, the system of this legal methodology is not a new one. Since 1956, even we talk about the before the Chanakya. First of all, if we start from Chanakya, we are aware that at that time also all the weighing and measuring instruments used to be verified and stamped by the government. It was a 7 function. Government has to do that. These weighing and measuring instruments used to be verified and stamped after every 6 months. Then we have the Mughal period, then British period, and after the freedom, we also have our own Weights and Measures Act 1956, then 76, and now we have the Legal Metrology Act 2009. It came into force from 1st of April 2011. All type of weighing and measuring instrument, maybe a weigh bridge, maybe a weighing machine, maybe a petrol pump, maybe a thermometer, blood pressure meter, all are covered under the legal methodology. Government of India has framed these 7 rules under the Act, General Rules 2011. The General Rule explains about all type of weighing and measuring instruments, how a weighing and measuring instrument will be manufactured, what will be its technical specifications, what will be its material, how it will be tested, how it will be verified and stamped. All provisions are given under the general rules. What will the periodicity of the verification? It has also been mentioned and obviously been very clearly mentioned under the general rules 2011. We have the packaged commodities rules. All prepackaged commodities available in the market are governed under these packaged commodities rules. What will be the declaration, how the net quantity, all these are covered under these packaged commodities rules. Approval of model before manufacturing or import of any weighing and measuring instrument. If anybody wish to manufacture or import a weighing or measuring instrument, he has to get the approval from the Government of India. And these approval rules prescribes how a weighing or measuring instrument which is manufactured or imported in our country will be approved, tested and approved. National standard rules, all type of physical quantities, maybe the Boltzmann constant, electronic charge, or anything, all are covered under these national standard rules. Even how the quantity will be converted from one unit to the another unit, base unit, complementary units, supplementary units, all are covered under the national standards rules. Numeration rules are one of the very important rules which prescribes how a number will be represented. At international level, we used to represent in terms of the digits of 3. After the decimal, 2 digits, and before the decimals in the 3 digits. But in India, we used to have a system of representing after the decimal 2 digits, before the decimal 3 digits, and then in terms of 2 digits, like lakh, karur, arab, kharab, Padam, Neel, Shank, like that. So this is the way how this international and the national systems of numeration are being made. Even when we see in Indian numeration system, if we see the ancient period, even till now, at the international level, we have not gone above 10 raised to the power 30. But when we talk about our Indian system, it represents up to 10 raised to the power 100. Long back at the ancient period, 10 raised to the power 100, which is now, even right now at international level, we have not reached more than 10 raised to the power 30. We have a training institute which is called Indian Institute of Legal Metrology. It is at Ranchi. Government approved test center rules or provision has also been made under the Legal Metrology Act 2009, because now the weighing and measuring instruments are increasing day by day. We are having about more than 5 crores of the weighing and measuring instruments which are already in use in our country. And the verification and stamping of all these weighing and measuring instruments is a big job. इतने सारे equipments को verify करना, stamp करना, उसके लिए एक provision बनाया गया है कि किस तरीके से जो रेस्पॉन्सिबिलिटी है वेइंग और मेजरिंग इंस्ट्रूमेंट्स को वेरीफाई और स्टैम्प करने की, उसको प्राइवेट पार्टीज के साथ, प्राइवेट लोगों के साथ, लेबोरेटरीज के साथ कैसे शेयर किया जा सकता है, उसके लिए गवर्नमेंट अप्रूव्ड टेस्ट सेंटर रूल्स 2013 बनाए गए हैं. अपार्ट फ्रॉम दिस, द स्टेट गवर्नमेंट्स हैव आल्सो फ्रेम्ड देयर ओन एनफोर्समेंट रूल्स. All the states have their own enforcement rules. This legal metrology act is applicable to all type of trade and transactions. It provides accuracy of quantity delivered in all transactions, how the declarations will be made, how the verification and the stamping of all weighing and measuring instruments will take place before sale or putting them into use, maybe a petrol pump, railway bridge, gold weighing machine, etc. Approval of model of GATC, yes, it is also very important. We have already seen. Without license, manufacturing, repairing, or selling of weighing and measuring instruments is not allowed. Only one director of the company or other person for any establishment or unit may be nominated for the compliance in the company. Transaction of solid commodities will be in kilogram. Liquid commodities like petrol will be in liter. So this is the way how these act, under this act, how these provisions are made. Under the Legal Metrology Act, this units of weighing and measuring instruments, units of weights and measures are very important, because this is the only act which prescribes the units in which unit a particular transaction will take place. For example, let's say for the mass should be in kg, kilogram, gram, or milligram, like that. The other units, like as we used to use earlier, Tula, Masha, Seer, Pond, etc., they are not allowed in our country. Only the MKS system of units are allowed, because we have already signed the meter convention in 1957. The unit of current will be ampere, temperature will be Kelvin, luminous intensity will be candela, amount of substance will be mole, and the length will be meter, time will be second. So these are the all units which we have already prescribed. CGPM, General Conference on Weights and Measures, in 2018, revised the definition of international system of units. New definitions came into force from 20th May 2019. We have already seen that up to 10 is about plus 30 and minus 30. We have seen not over even at the international level, we have not gone over plus 30 and below minus 30. But at international, when we see Indian level, it is up to 10 is about plus 100. See, now, all these physical constants, whether we are talk about the kilogram, meter, second, etc. Earlier, we used to say that 1 kilogram is the mass which is placed in Paris. This is a cylinder, this is a crystal, or this is a small metal which is made up of platinum and iridium and placed at Paris. This is of 1 kg. Every year, all the countries used to go over there. They used to calibrate their national standard from that weight 1 kg, and then they used to calibrate all over the country. This is a complete structure all over the world we are using. But now we have removed these artifacts, and now all these base units are linked with the natural constants, universal constants. For example, kilogram is linked with the Planck's constant. How many Planck's constant will form 1 kg? In other words, or in simpler language, I can say meter, speed of light. Second, hyperfine transition frequency of cesium atom, which we are all aware, 9, 192, 631, 770 times of cesium atom vibrate in 1 second. This much is the frequency which we are aware. 9, 192, 631, 770 times is the frequency of frequency of cesium atom, which is equivalent to 1 second. Charge 1.6 into 10 to the minus 19 coulomb, which is equivalent to 1 ampere. So this is the way how all these physical constants, how these base units have been defined with the universal constant. All of them have the zero uncertainty. This is the hierarchy chart. How the mass is linked with international standards. Yes, somebody is asking. I would like to inform you, this whole video as well as this whole PPT will be available on our portal jagograhakjago.gov.in/seminars. Even the earlier PPTs, all the certificates which are issued are already available on our website. Anybody can see. Even this is also available on the YouTube channel. It is these programs all are always live programs on the YouTube channel. Anybody can see even on YouTube or are on our video or on our website through the video, can download the video. This is the hierarchy chart. First of all, we have the international standard. Then we have national prototype. National prototype is placed at National Physical Laboratory, New Delhi. National Physical Laboratory, New Delhi is responsible for maintaining and keeping the national standards. Then we have the reference standards under the legal metrology. All these reference standards laboratories are verified, are getting verified their weighing and measuring instruments from this national prototype after every 10 years. Then we have secondary standards which are verified after once in 2 years, working standards once in a year, commercial weights once in 2 years. So this is the way, this is a complete hierarchy chart how we are maintaining all over the country, from the international prototype to the commercial weights which are used in the transactions. Regional reference standards laboratories, at present we have 6 RRSLs, regional reference standards laboratories, working under the administrative control of the department, and these laboratories are at Ahmedabad, Bangalore, Bhubaneswar, Faridabad, Guwahati and Varanasi. These laboratories actually work as a link in between the state government legal metrology departments and the apex level laboratory, which is the National Physical Laboratory. These laboratories used to perform the testing of weighing and measuring instrument for model approval, verification of legal standards of states and UTs, calibration of weight and measures of industries, dissemination of Indian Standard Time, and outreach programs. These are the functions of these legal metrology laboratories. We have the training institute. It provides training to all the legal metrology officers, international legal metrology officers, or the repairers, manufacturers, assistants, and they also provide large number of awareness programs they used to conduct on a regular basis. This is one of the best institute in South Asia. We also provide the training on legal metrology to the neighboring countries. Large number of neighboring countries participants are deputed regularly at this institute for training purpose. It is a wonderful and beautiful place at Ranchi, where we have all the facilities, all the advanced facilities of stay and everything. The Legal Metrology Act is very useful, very important for these two purposes. Any weighing or measuring instrument which is used for protection or transaction, any weighing or measuring instrument which is used for protection, any instrument, if we are using the observations or the readings of this weighing instrument for the purpose of determining any step which is used for safeguarding the well-being of any human being, animal, or vegetation, then it will be covered under the term protection. For example, a blood pressure meter, a thermometer, because the doctor many times prescribes the medicines on the basis of the readings or the observations they used to take from these blood pressure meters and the thermometers. So this definition of protection covers not only the human being but also animal as well as the commodity. Transaction, any contract, whether for sale, purchase, exchange, or any other purpose, any assessment of royalty, toll, duty, or other dues, or the assessment of any work done, wages due, or services rendered. So any type of transaction which is taking place cannot go beyond these definitions. Any contract for sale, purchase, exchange, assessment of royalty, toll, duty, assessment of any work done, wages due, or services rendered. So for these purposes, the Legal Metrology Act and the verification of all weighing and measuring instruments covered under these definitions is mandatory. Seal and stamp. Seal is nothing, it is a process by which we used to pass a wire and put a stamp on this wire to ensure that this weighing and measuring instrument is now as per the standards or complying the standards made under the Act, and the mark which was made earlier, that has been either removed or that has been confirmed that it is okay. Verification, with its grammatical variations and cognate expressions, includes in relation to any weight or measure the process of comparing. Basically, we have one standard equipment and one equipment which is under test. We used to compare both of the instruments. Let's say the one is the standard weight and another is the test weight. We used to compare both of these two weights, adjust them, test them, check them with a view to ensure, and we used to ensure that the weight or measure is conforming to the standards established by or under this act, and also includes re-verification and calibration. If we are doing the re-verification, it is also covered under verification, or if we are doing calibration, it is also covered under verification. So verification includes calibration as well as re-verification, and verification is nothing, we just ensure that a weighing or measuring instrument is correct as per the standards of act or the rules made under the act. Label, any written, marked, stamped, printed or graphic matter affixed to or appearing upon any prepackaged commodity. You have seen that the weighing and measuring instruments or all the prepackaged commodities have a sticker over it or a label over it. On this label, they used to declare all the declarations required under the packaged commodities rules. These are the few compliances which need to be done. If anybody is importing a weight or measure, he need to get registered under section 19. No non-standard weight or measure can be imported. Every person before manufacturing or importing any weight or measure need the approval. Before manufacturing, selling or repairing any weight or measure, a license is required from the controller. Any weight or measure which is used in any transaction or production need to be verified and stamped under section 24 of the Act. We have also introduced a new concept of unit sale price, because earlier there was a concept of we were having the second schedule. Under the second schedule, 19 commodities were made that were having the prescribed sizes. How much size will be there? But with the development of time and with the passage of time and requirement of the industry and the market, it was requested that now the market should be free and we can pack the packaged commodities in as per the required quantity wherever whatever required. So the concept of this 19 commodities under which these commodities need to be packed in the prescribed sizes was omitted, and we have introduced a new concept of unit sale price. Under this unit sale price, you have to declare what is the price per unit, that means price per gram or price per ml. Declaration of month and year of manufacture only. Earlier it was allowed to declare the month and year of import or the month and year of pack, but now it is mandatory to declare month and year of manufacture only. Electronic products to declare certain declarations through QR code also. Earlier, all the declarations were need to be made on the prepackaged commodities, but for electronic products, very few declarations which are not required to be seen at the time when the buyer is going to buy the product may be made through the QR code. Based on measures which are used by the industries for their internal use do not require re-verification. A uniform procedure has been adopted in the country to avoid double stamping. We have decriminalized few sections under Jan Vishwas 1, Jan Vishwas Act 2023. We have actually decriminalized these 7 sections of the Legal Metrology Act. Section 25, which speaks or which is related with the penalty for use of non-standard weight or measure. If due to use or due to regular use or continuous use, any weighing or measuring instrument has lost is standard or something, or it is not basically verified or something, in that case, this is now not criminal. It can be made compoundable. It has been made compoundable. Penalty for manufacture or sale of non-standard weight or measure. Penalty for making any transaction, deal or contract in contravention of the prescribed standard. Penalty for making any transaction, deal or penalty for quoting or publishing of non-standard units. Penalty for non-production of documents. Penalty for sale or release of commodities by non-standard weight or measure. Penalty for rendering services by non-standard weight or measure. So all these sections were earlier criminal sections, but now they have been made decriminalized, and now the compounding can be done. Under Jan Vishwas Bill 2, we have proposed these few of the more sections: alteration of weight or measure, transaction in contravention of standard weight or measure, failure to get model approval, use of unverified weight or measure, selling etc. of non-standard packages, non-registration by importer of weight or measure, import of non-standard weight or measure, giving false information or false return, manufacture of weight and measure without license, repair, sale, etc. of weight or measure without license, tampering with license. All these provisions we are going to decriminalize under Jan Vishwas 2 shortly. We have also introduced a new concept of improvement notice. In case of the first offense, in few offenses, the improvement notice can be issued. Such notice will act as a warning to the businesses which fail to comply with any regulations to which this section applies. These are the sections under which we have made the provision for issue of improvement notice. Even the section 25, section 27, section 28, 29, 31, 32, 33, 34, 35, 36, 1, 38, 39, 41 and 41, 1 and 41, 2, 45, 46, and 47. In all these offenses, in all these sections, we have made the provision of issuing in first offense the improvement notice so that the businesses can correct their offense, their non-compliances, and can be given the first opportunity to get correction. Sections where only the compounding fees is prescribed for use of unverified weight or measure and contravention by government approved test center. So at these two sections, only the compounding will be done. Other sections proposed for amendment under Jan Vishwas 2, compounding of offense, we have made this provision that, and after subsection 4, that provisions made that provided that the person who commits the second or subsequent offenses compound the offense before the institution of the prosecution on payment for credit to the government. Appeals in section 50 in subsection 1. In clause C, after the words the central government, the words or any officer especially authorized in this behalf by that government shall be inserted power. As we are all aware, where no provision has been made at present, the maximum penalty can be waived. It can be made up to rupees 5,000, which has been increased for the central government up to rupees 5 lakh, and for the state governments from 5,000 rupees it has been made up to 1 lakh rupees. So how we are actually amending this legal methodology, proposing the amendment of this Legal Metrology Act 2009. Under section 40, the provision was for obstructing director, controller, or legal metrology officer. Now we have omitted this provision and we have made that the provisions made under BNS Bharatiya Nyaya Sanhita 2023 shall be applicable. This is one another very important concept of the legal under the legal methodology we are doing. We are working on dissemination of Indian Standard Time at present. The time is being taken from GPS, geostationary positioning satellites of USA. We are planning to have our own Indian Standard Time because the National Physical Laboratory and the ISRO, they are maintaining their own Indian Standard Time with their satellites, and National Physical Laboratory being the primary, being the first body which is, or the national laboratory, which is actually the national timekeeper of the country. They used to generate and maintain the Indian Standard Time. We are planning to have this time to disseminate all over the country, which is very useful for cybersecurity, networks, data centers, disaster management, defense, telecommunications, and 5G, digital signatures and time stamping. Dissemination of IST will be through regional reference standards laboratories in coordination with NPL and ISRO, and we are in the final stage of disseminating time through NTP, Network Time Protocol. I have a small video I just share who have not seen.
As millions in India go about their daily lives, a silent times revolution will unify and synchronize India into a single time reference, that is, the Indian Standard Time. New India will herald a time of its own, a synchronized system which will disseminate India's time to come uniformly across all corners of India. Telecom service providers and internet service providers are synchronized to NIST USA time, either through GPS or NTP pool. As a result, there is always uncertainty of time, like the time of your Aadhaar authentication or at the time of Indian Railways ticket booking and the airports, communication devices across country. In order to cater to the ever-increasing needs of India Standard Time by several organizations in the country, the dissemination of time will be done by Ministry of Consumer Affairs, Food and Public Distribution through its regional reference standards laboratories from 5 geographical regions of the country. So in terms of cyber security, where every second is crucial, where within a fraction of a second, thousands of emails and digital messages are sent and received across the continent.
Yes. So we are working to disseminate this time. The timing scale integration has already been completed at all four RSLs, Ahmedabad, Bangalore, Bhubaneswar, and Faridabad. And very shortly, it will be done by the end of this month. We will also have the establishment of these timing scales at Guwahati also. Disaster recovery center is also being set up at Bangalore to restore disrupted systems, data, and applications after a disaster or significant disruption. Key highlights: we are defining the Indian Standard Time under the Indian Standard Time Rules 2025. We are also making the mandatory use of IST, penalties for non-compliance, exception to use of IST. Draft rules were uploaded on the website for public comments, and we are in the final stage to finalize these drafts and notify. As we are all aware, India is the OML member country since 1956. We signed the Meter Convention in 1956 and we became the member in 1957. The OML was established in 1955, having its headquarters at Paris, 63 member states, including India, and 64 corresponding members. The purpose of this legal methodology is to harmonize the global national laws or the national and the laws and the regulations on performance of measuring instruments, facilitate international commerce of measuring instruments and affected products, ensure quality measurements for public and worker health and safety and protection of the environment, harmonize national procedures of testing and verification to ensure the performance of measuring instruments. As India became the 13th country in the world which can issue the OML approval certificates, we are actually testing these weighing and measuring instrument to issue the OML approval certificate. This is the website of the OML where it is mentioned that the department is making this now capable to issue the OML approval certificates. We have issued few OML approval certificates of the dispensing units manufactured in our own country, India. There are a few advantages: standardization and cost reduction. Obviously, now the weighing and measuring instruments which are manufactured in our country, they are standardized, and obviously when the testing is done once, there is no need to get it tested again whenever we are selling it outside the country, which reduces the cost. We can generate the revenue. We can also impact on the OML policies because we are the member of this country, we are the OML member country, and we can expand our export, influence other member states, and enhance reliability and authenticity. So these are the advantages of becoming the OML member country and the issuing authority. These are all type of weighing and measuring instruments which are covered under the legal metrology. These are the few new weighing and measuring instruments which we are going to develop, like gas meter we have already done, moisture meter we have already made, but for energy meters, electric vehicle charging, LNG, hydrogen cars, these are all required to be again covered under the general rules or the Legal Metrology Act, so that they can also be tested and verified on regular interval of time to ensure their correctness. Prepackaged commodities are defined under Section 2L of the Legal Metrology Act. Prepackaged commodity is nothing. It is a commodity which was packed when the purchaser was not present, and it has a predetermined quantity. It has a predetermined quantity and it was packed when the purchaser or the consumer was not present. Section 18(1) prescribes about the provides for the declaration part. Any prepackaged commodity, whenever we are manufacturing, packing, importing for sale, it should have all the declarations. Section 18(2) provides that any advertisement mentioning the retail sale price shall contain the net quantity. It is very much required that the net quantity should be mentioned, should be declared on the prepackaged commodity. Wherever we are making a declaration or an advertisement and we are saying that this much is the price of a prepackaged commodity, then what is the quantity inside this prepackaged commodity need to be mentioned, need to be declared, or need to be advertised. Section 36(1) is the penal provision which prescribes for selling, manufacturing, packing, importing, distributing, delivering, or otherwise transferring, offering, exposing, or possessing for sale any prepackaged commodity which does not conform to the declarations of the package as provided in the Act. Fine may be up to 25,000 rupees for the first offense, second offense up to 50,000 rupees, and for subsequent offense not less than 50,000, but it may go up to 1 lakh or with imprisonment up to 1 year. If there is an error in the net quantity, selling, manufacturing, packing, importing with error in net quantity, the fine is in between rupees 10,000 to 50,000 rupees for the first offense, and for the second and subsequent offense, the provision is up to the imprisonment up to 1 year, or fine which shall not be less than 50,000 rupees, but it may go up to 1 lakh rupees or with both. So these are the provisions, penal provisions made under the Act for the prepackaged commodities. Rule 2H of the prepackaged commodities or the packaged commodities rules 2011 prescribes the principal display panel in relation to a package means the total surface area of the package, where the information required under these rules are to be given in the following manner. All the information could be grouped together and given at one place. The pre-printed information could be grouped together and given in one place, and an online information grouped together and given at another place. Legal Metrology Packaged Commodities Rules 2011. What are the mandatory declarations? Name and address of the manufacturer, packer or importer. Country of origin in case of an imported package. Common or generic name of the commodity contained in the package. These are the just very important declarations which need to be given on all prepackaged commodities. Name and address of the manufacturer or importer or the packer. Country of origin, common or generic name, net quantity in terms of standard unit of weight, measure or number, month and year of manufacture, retail sale price inclusive of all taxes in Indian currency, unit sale price, past before or used by date, month and year, if it becomes unfit for human consumption, sizes, dimensions of the commodity if relevant, and consumer care details, email ID, phone number, address, name, everything should be given for the consumer care details, so that if there is a dispute in between the consumer and the business, it can be resolved at the business level itself. For e-commerce entities, it is mandatory to declare, to ensure following mandatory declarations. What are these declarations? Name and address of manufacturer or importer, country of origin if imported, common or generic name of the commodity, net quantity in a standard unit of weight or measure or number of commodity in the package, MRP inclusive of all taxes, past before or used by date, month and year in case of commodity becoming unfit for human consumption with time. As we have already discussed, the principal display panel, total surface area. If I talk about this, this is, let's say, this is a product. If you see in this product, is it visible? So the total surface area of this product from all sides is covered under the prepackaged commodity under the principal display panel. If the area principal display panel is less than 50 square centimeter, then the height of the numeral and the letter shall be 1 mm. It should not be less than 1 mm. But if it is molded or blown or formed, it should be 2 mm. If the size of the principal display panel is in between 50 and 100, when it is printed, the declaration should be in the size at the size of 1.5 mm. When it is blown or molded, it should be 3 mm. In between 100 to 500, the height should be height of the numerals and the letters will be 2.5 mm when it is printed, and it should be 4 mm when we are doing it, when we are actually molding it. For the packages having the sizes in between 500 to 2500 square centimeters, it should be 4 mm and 6 mm, and when it is more than 2500 mm, it should be 2500 square centimeter. The principal display panel, the size of the letter and numeral will be 6 mm whether it is printed or molded. In all the cases, it will be 6 mm. These are the maximum permissible, these are the few provisions that no retail dealer or other person, including manufacturer, packer or importer, anybody, shall make any sale of any commodity in packaged form at a price exceeding the retail sale price. What is the maximum retail price declared on the package? Nobody is allowed to sell over and above the MRP. Unless otherwise specifically provided under any other law, no manufacturer, packer or importer shall declare different MRPs on an identical prepackaged commodity by adopting restrictive trade practices or unfair trade practices as defined under clause 41 and 47 of the Consumer Protection Act. It is very important. No dual MRP is allowed on an identical pre-packaged commodity. No wholesale dealer or retail dealer or other person shall obliterate, smudge or alter the retail sale price. It is very important that anybody who is going to manufacture, pack or import the prepackaged commodity, he has to get registered himself either with the director of the legal metrology or at the state level with the controllers of the legal metrology within 90 days from the date on which he or it commences such packaging. And for the director legal metrology, if you want to get the registration, it can be done online on nsws.gov.in. Then we have to go in the central government approval, registration of manufacturer of packaged commodities, and you will get this registration done online. These are the maximum permissible errors on the quantity declared by weight or measure or number. If the declared quantity is 50 gram or 50 ml, then the maximum permissible error allowed is 9%. For example, if the packaged commodity is of 30 ml, then at 9% it becomes 3.6 ml. This is the maximum permissible error allowed for a package having 40 ml inside the 40 ml quantity inside net quantity inside the package. If the net quantity is in between 50 and 100, 50 to 100, the error allowed is 4.5 gram or 4.5 ml. 100 to 200, it is 4.5%. Again 200 to 300 gram, it is 9 gram. 300 to 500 gram or ml, it is 3%. 500 gram to 1000 gram, that means from 5 kg 500 gram, that means from half kg to 1 kg, the error allowed is 15 gram. From 1 kg to 10 kg, it is 1.5%. And from 10 kg to 15 kg, it is 150 gram. And more than 15 kg, it is 1%. So it is very simple. All packages more than 15 kg are allowing the maximum permissible error is 1%. Also, in case of the length, 2% of the declared quantity up to 10 meter and thereafter 1% of the declared quantity. In case of area, 4% of the declared quantity up to 10 square meter and thereafter 1% of the declared quantity. By number, 2% of the declared quantity. In case of when we are going the net content checking or the inspection of quantity and error in the packages, we actually find the corrected average of the net quantity contained in the package, which from the samples drawn is lesser than the quantity declared. If the corrected average net quantity is less than the quantity declared on the package, or the number of packages that show an error in deficiency exceeding the maximum permissible error is greater than that shown in column 4 of table under 5th schedule, or any such package shows an error in deficiency exceeding twice the maximum permissible error. In all these cases, the director or the controller or the legal metrology officer shall require the manufacturer or packer to a 100% check of the packages contained in the lot and authorize sale, distribution or delivery of only such packages with error in deficiency in the net quantity less than the maximum permissible error, and the remaining packages shall be allowed to be sold, distributed or delivered by the manufacturer or packer after it has been repacked or relabeled as the case may be, so as to comply with the provisions of the Act and the rules. So what is the corrected value actually? Corrected average net quantity, which is known as XC. First of all, we used to take the samples, and from the samples we find the standard deviation. Mean value, Xi is the individual value, X bar is the average or the mean value. Then we find the sigma or the standard deviation. Then the corrected average Xc is nothing, it is X bar, which is the average value, plus sigma, that is the standard deviation, multiplied by C. C is the correction factor, which is a constant. So from this formula, we get the Xc, corrected average net quantity. What is the correction factor? C. For the packages, if the lot size is 100 to 500, packages sample size will be 50, correction factor will be 0.379, and number of packages which may show error more than the permissible error, maximum permissible error, but less than twice the maximum permissible error are only 3. 500, 1 to 3200, 82, number of sample size will be 80, correction factor will be 0.295, and the packages will be 5. More than 3200s, the sample size will be 125, correction factor will be 0.234 and number of packages shall be 7. So this is the way how we used to calculate the net quantity inside the packages or in the packages. Unit sale price, we have also discussed that this unit sale price should be rounded off and declared in the nearest 2 decimal places. It will be in per gram when the quantity is less than 1 kilogram, and in kg if it is more than 1 kilogram, per centimeter when it is less than 1 meter, and per meter when it is more than 1 meter, per milliliter when net volume is less than 1 liter, and per liter when it is more than 1 liter, per number of unit if any item is sold by number of unit provided. But this unit sale price is not required to be declared on the packages containing alcoholic beverages or special liquor, where the state excise laws and the rules made thereunder are applicable within the state where it is manufactured. Provided further that the declaration of USP unit sale price is also not required for the prepackaged commodity in which the retail sale price is equal to the unit sale price. For example, the package is 1 liter. So unit sale price as well as the retail price both are the same. So in that case, this declaration of unit sale price separately from the MRP is not required. This is the exemption clause. These are the new definitions: combination package, group package, and multi-piece package. For these packages also, the declaration of unit sale price is not required. If it is a combination package, means a package which has different type of articles, maybe cups and plates, napkins, forks, etc. So these are the examples when these are the two unidentical, just different packages, individual packages, dissimilar commodities. Group packages, similar commodities but of different quantities. For example, two is a package containing assorted biscuits of different quantity. It is known as a group package. Multi-piece package, same commodity, same quantity, but it is known as the multi-piece package. For example, 5 toilet soap cake of net weight 20 gram each and total net weight of 100 gram is a multi-piece package. So these are the examples of group package, multi-piece package, and the combination package. And for all these packages, the declaration of unit sale price is not mandatory, is not required. For the electronic and the spare parts and accessories, we have also made them exempted to declare the month and year of manufacture for spare parts or accessories, provided they are used for the purpose of servicing with a warranty. Whenever they are used in an industry or by the service provider with a warranty, then there is no need to declare month and year of manufacture. Month and year of manufacture for electronic products may be declared at any place. It is already allowed. For the loose commodities ordered through e-commerce, these are the only requirements which need to be made: name and address of manufacturer or marketer or brand owner, consumer care email ID and phone number, retail sale price of the package inclusive of all taxes in the Indian currency, and the net quantity in terms of standard unit of weight or measure, or where the commodity is sold by number, the number of the commodity. In case of the electronic products, these are the few declarations which do not need to be declared on the package itself. They can be given through QR code. Name of the manufacturer need to be given on the package, but the address may be given through the QR code. The common or the generic name may be given through the QR code. Size and dimension may be given through the QR code. Telephone number and the email ID will be on the package, and rest declaration name and address may be given through the QR code. But all this information should be given on the package, that this information is available through the QR code. You can scan the QR code and can get this information. For the garments or the hosiery which is sold in loose form, these are the only few declarations: name and address of the manufacturer or marketer or brand owner or importer, consumer care email ID and phone number, sizes in metric notation as the case may be, or with internationally recognizable size indicators such as SML, XL, etc., along with the details in metric notation. Maximum retail price of the package. Exemption shall be applied to sale of finished products alone. The above information shall be displayed on e-commerce websites if sold through e-commerce website. So these are the basic requirements for the garments industry. For the different establishments or the branches or the units, different persons which have the control, authority and responsibility of planning, controlling and directing the activities of the establishment or branch or unit may be nominated under section 19, under section 49 of the Legal Metrology Act 2009 by a company. Company may nominate any of the director for all branches, for all its units, and even including the company registered address, corporate address, for anything. For everything, they can declare only one person responsible, or they may declare different persons for different establishments, branches, or units. These are the, if we see that these number of nominations we have done, if we see even during this year, we have done 3036 nomination of directors till now. Packaged commodities, manufacturer packers, we have already done 7208. For registration of importers of weights and measures, 154. Model approval, we are actually getting regularly the less number of approval of models, because we expect that large number of approvals have already been done, and now the manufacturers are using those approvals again. We also have the national single window system. All the exercises are through national single window system. We also issue the notices for the violations of the provisions of the Legal Metrology Act and the packaged commodities rules. Now we have made a provision that whenever any amendment will be made under the packaged commodities rules, it will come into force either from January 1st or July 1st, giving a transition period of about 180 days. The purpose of this amendment to give the ample time for the industries to adapt to the change. However, when we suppose there is a flexibility or there is a facility which is given to the industry, it may be immediately given. However, they can use it wherever they want after maybe 6 months. We are also developing a new EMAP portal by which all the activities, all the services of the legal metrology of all states and UTs, including the central government, will be available on this portal, EMAP portal. Very shortly, it will be in functioning. It will be in function. These will be the facilities, or these are the broad ideas which we are considering. Comprehensive online services, all the states and UTs will be onboarded, key advantages and action points. We have also developed the software testing facility. My request to all participants, I am not going to, because it will be difficult for me to share through the email IDs. What I will request you, kindly check on our portal, jagograhakjago.gov.in/seminars. Even you can see this, but this is available at all places. This particular website or this particular portal is available. You could just go through it, go over there, and you will find all the videos, all the presentations are available from the very beginning. Since last many years, it is available. This software testing facility we have developed, or we are developing at all 6 regional reference standards laboratories. The purpose is to test the software and the electronics, and we can ensure that the chances of tampering can be removed. These are the new weighing and measuring instruments which we have recently implemented, or which we have recently notified. Radar equipment for measuring the speed of vehicle. Gas meters, which are used for the domestic, commercial and the industrial purposes, as we know that now the gas is through the pipelines. Moisture meter, this is also notified, and now very shortly we are going to enforce all these provisions. These are the few more equipment: catch weighing instrument, breath analyzer. All these weighing and measuring instruments we are bringing very shortly under the purview of the Legal Metrology Act 2009. These are the GST reforms we have given. That this is the historic GST reform approved by the GST Council with new rates which were effective from September 22. Now we have 2 major slabs of 5% and 18%, and a 40% rate for demerit goods. We have allowed the manufacturer, packers and importers to voluntarily add revised MRP stickers on unsold packages manufactured before September 22. Original retail sale price declarations must remain visible and unobstructed. Revised unit sale prices on pre-printed MRP packages are not required. Unit sale price is not mandated to be declared in case of pre-printed packages. Must send circulars about revised MRPs to wholesale dealers, retailers, and director of the central government and controller legal metrology of all states and UTs. Mandatory sensitization through electronic media, print media, and social media platforms. Industries to ensure to pass on the benefit of reduced GST rate to end consumers. We also have provision of Jan Sunmai on every Tuesday, 4 p.m. to 5 p.m. This link is available on our website. And every Tuesday, we used to discuss the issues of the industries, how we can support the industry, what are the challenges industries are facing. We have also made it mandatory that to use 1 milligram weighing or weighing machines for the sale of gold and precious metals. Requirements on even E2 class weights have been received, and we are simply distributing these weights to all states and UTs. We have also made the provision of this auto renewal of licenses. In many states it has already been done, and few more states it is being done. So this is enough only, and I just wanted to share this. These are the few provisions which we have made under the Legal Metrology Act. I have a provision of few questions. We have 20 questions, which I am sharing you the on this PPT. Just 1 minute. Jetulji, I am just sharing with this people. Oh, I'm sorry, I was muted. See, this link is available on our, I have just shared this link in this chat box. You can open this link. There are 20 questions. You please take part in this quiz. In these questions, just reply, answer in the question in the Google Sheet itself, and we will issue a separate certificate for these questions for this exam. I am again sharing this PPT where this link is mentioned. Yes, this is a link. You may take 10-15 minutes to reply these questions. This link is open. This is available on YouTube channel as well as in the chat box and the PPT. From the chat box, you can get it copied. Atulji, can we make, in the meantime, can we make all the participants, the panelists?
Yes, sir.
Ahmedabad also, yeah. Yes, they have already, they have already been made. The panelists. My request to all participants to kindly switch on your video so that we can take few photographs. Atulji, please take the photographs. Now I am going to thanks all the participants. You have to submit your reply in this Google Sheet itself after this immediately, and you will get all these certificates, video, as well as the PPT on our portal. Thank you very much. I would like to thank all the participants. Can we close, Atulji?
Yes, sir.
Thank you. Now the chat through in the chat box as well as in the YouTube channel, I think everybody has got. My request to all the participants: if you are not available on this in the WhatsApp group, kindly share me your number in my WhatsApp so that I can add you in my WhatsApp group. Thank you. Thank you very much. Thank you all.